By no means could it be said that what the government was doing was necessary to achieve its objective, or even a reasonable way to accomplish it. Another way in which we can criticize Korematsu is in terms of its later doctrinal effect. Now, at first, it's not obvious that there was a later doctrinal effect. Thankfully, the United States Supreme Court has not relied on Korematsu in subsequent equal protection rulings. But I would suggest that Korematsu is part of a trend that very much continued and actually preceded Korematsu. And I think it's one of the worst aspects of American history. It's that in times of crisis, especially foreign-based crisis, we compromise our most basic constitutional rights, only to realize in hindsight that we weren't any safer. I've often thought of this as Korematsu reinforced a deck chair theory of the Constitution. We regarded the Constitution like deck chairs that we put out in sunny weather. And then, in wartime or a time of crisis, we take out the deck chairs, we bring them inside, we bring the Constitution inside, and we ignore it. But of course, the Constitution is most important when we can't trust the majority, we can't trust the government. That's what it's there for. And Korematsu is an instance where the government took away liberty without making us any safer. Not one Japanese American was ever accused, indicted, or convicted of espionage or any crime against national security. Now, this trend that I'm talking about, this deck chair theory of the Constitution, started early in American history. I think the Alien and Sedition Act, as adopted in 1798, might be seen as part of it. President Lincoln suspending the writ of habeas corpus during the Civil War, and people being incarcerated just for criticizing how the Civil War was being waged is an example of it. I think the cases during World War I, where individuals were imprisoned for criticizing the draft and war effort is part of it. I think the cases during the McCarthy era, like Dennis, where individuals were being imprisoned just for teaching works of Marx and Lenin, Engels are part of it. I think the Supreme Court's decision last June in Humanitarian Law Project versus Holder is part of it, where the Supreme Court said American citizens could be convicted of material assistance to foreign terrorist organization just for advising foreign groups how to use international law for peaceful resolution of disputes or how to apply for humanitarian assistance. The court required no showing of any likelihood that the speech would increase terrorist activity or even the possibility of it. And so I think in that sense, Korematsu is part of and reinforced a very bad doctrinal aspect of American constitutional law.